And in many ways, that has been fueled by the blue bar, the number of criminal record intakes, which is quite phenomenal. At this point, it has exceeded 1,000 a year. So really, part of the reason the employment intake keeps going up is the demand regarding criminal record issues. So naturally, that's one of the topics I'll be talking about. But again, the point here being there's quite a demand for employment-related advocacy here in Philadelphia, and I'm imagining where you are as well. So today we're going to cover the following things to the extent that I can in the hour that we have. What a legal aid employment practice looks like, and that's not because I expect you will all run out and make one, but to give you a sense of the issues that are important to low-wage workers and the unemployed. Basic employment law concepts, family and medical leave, which I consider one of the most important employment law statutes for our clients, and criminal records. These are the reasons we have an employment practice at CLS and why other legal aid programs have started one as well. It is in many ways a very gratifying practice because it helps clients help themselves. And so removing barriers is probably our #1 priority. Those barriers are often related to criminal records, but they could also be child abuse records or disability barriers. Establishing eligibility for income streams like disability insurance and pensions, taking care of low-wage workers when they're abused, which is often around issues of wages, but could be occupational health and safety as well, and recognizing that a high percentage of our clients either work or would really like to work. And so our matching up our goals to the type of work that we do, this shows you the type of cases that CLS takes for the most part as our employment law priorities. Many of these I've already spoken about, but let me mention in particular preserving the ability to work. I think that's another very important goal. We help a lot of folks keep their occupational licenses or stay off of patient abuse registries, because as all of us who are lawyers recognize, if we don't have the license to do what we are trained to do, it's very hard to earn a living. What we don't do is a lot of what the private bar might do to a certain extent, which most notably, we don't do a lot of discrimination cases in our practice. And the reason behind that is that they consume a lot of resources and often come to nothing. And there are some private lawyers who are willing to take the discrimination cases, which is not the fact for many of our other areas that we work in. And we also avoid at-will and unionized employer terminations. Federal employees tend to have very obscure rules that apply only to them, and we don't do workers' comp because there's a private bar for it. So again, I bring this to your attention so that you know what a legal aid practice looks like, given that private practice in employment law does not look like this at all. It tends to focus on claims that can be litigated, and that's really not what we're doing, and certainly not with the number of clients that are presenting every year. All right, so starting with basic employment law. Probably most of the people on this call have heard about employment at will, but just to make it clear, since this is the bedrock principle, basically anybody can do anything to anyone at any time for any reason, so long as it's not specifically illegal. And that often is confusing when you actually look at case facts in practice, because you'll see something that seems so patently unfair you can't believe that it can possibly be legal. You know, suppose somebody is fired for wearing the wrong colored shirt on a particular day. That falls into the category of stupid but not illegal. So this is the general rule of employment law, employment at will, and really what people consider the bulk of employment law are the exceptions to this general overall rule. So employment at will does not apply in these categorical areas. If you have a union contract, if you're a government worker with civil service protection, or if you have an actual contract, which is very rare for most people. I suppose if you're a professional athlete, you might be most likely to have a contract, but not the folks that we see. Higher level, higher income clients of private lawyers sometimes have contracts. So the difference between employment at will and these categories are that, first of all, you're likely to have a limitation on when you can be fired, and that limitation is often described as there being just cause, i.e. there must be a good legal reason for the firing. And number two, the employee is typically entitled to a hearing in which they can show that there was a lack of just cause. So for instance, in a union setting, that would be a union arbitration or grievance. In a civil service setting, it would be a civil service hearing. In a contract setting, it would probably be the courts. Now, in addition to those three categorical broad exceptions, the other major set of exceptions from employment at will are statutory exceptions. And the most important of those are employment discrimination laws, and we have those at the federal, state, and local level, often at the local level, but certainly at the federal and state level. Other employment statutes, like the Family Medical Leave Act, and in most cases where you have statutory rights, there are also rights to be free from retaliation from making a claim. So that would be, for instance, if you were trying to get your wages and you were penalized for that, you would have a right to get your job back because they cannot retaliate because you were trying to enforce the law. Employment discrimination, not an unusual concept for most of you, I'm sure. These are the general types of bases for discrimination that are illegal. I think, as I said, most of you know these. Just a minute to talk about sexual orientation. Currently, there is no federal or state law that prohibits discrimination in employment based on sexual orientation. A growing number of communities in Pennsylvania have laws that prohibit it. Philadelphia, for instance, is one. And there's been discussion at both the federal and state levels of potentially amending our existing employment discrimination laws to add sexual orientation to the list of things that are prohibited bases of discrimination. But as of now, that simply does not exist at the federal or state level. What is not employment discrimination? I have had many conversations over the years when I've asked clients about whether they've been discriminated against, and they respond with one of these two things, that there was different treatment, but it was based on some other reason. So client A and person B are in the same situation and they're treated differently, but you can't say ultimately that race or gender or age were the reason for it. That is not illegal discrimination. That gets back into employment at will then, unless one of the categories of exceptions like having a union contract applies. Then there's the dreaded personality conflicts. Clients often think that that is discrimination. He just didn't like me, my boss. Again, unless it is based on the reasons of race, gender, age, disability, etc., it will not be illegal employment discrimination as that term means under the law. Doing a quick canvass of the federal civil rights laws, Title VII is the granddaddy of them all. It does not cover all types of discrimination. It focuses on race, national origin, gender, including sexual harassment, and religious discrimination. And bear in mind that it applies only to employers with 15 or more employees. So if there are fewer than 15 in a particular work site, you have to look elsewhere for your coverage, probably under the state law, which we'll get to in a minute. Age discrimination is prohibited by the Age Discrimination in Employment Act, the ADEA, And this is a little interesting in that it applies only to employers of 20 or more employees. I do not know why, but it does. So again, smaller employers may not be covered. And it's important to know that it only prohibits discrimination against applicants who are at least 40 years of age or older. Sometimes we see younger people who say, I've been discriminated against based on my youth. That is not illegal discrimination under federal or state law. The Americans with Disabilities Act is well known in part because it applies not only in employment but also to various public accommodations and whatnot. In the employment context, it applies to employers, again, of 15 or more employees. It has a definition of disability that's extremely important. Traditionally has applied to more serious or chronic conditions and not short-term conditions such as, say, having a broken leg, something that will heal quickly. It is an important statute because unlike the other employment discrimination statute, it not only applies to intentional discrimination, in other words, where somebody is discriminating because they hate disabled people, but it also requires there to be reasonable accommodations of a person with a disability. So that provides a lot of leeway to help people who need adjustments in order to stay on the job. So here is a slide about the reasonable accommodation requirement. Some very common reasonable accommodations include reassignment of job duties where necessary, transfer to a vacant job. Note, not a creation of a new job, but if there's a vacant job that is open that the person with a disability could perform, they can ask for that as a reasonable accommodation. They might get their work schedule adjusted. Also possible under the Family and Medical Leave Act, and there tends to be a lot of complicated overlap between those two laws. Really, under the concept of reasonable accommodation, it can be as broad as your imagination is, but these are a couple to types of accommodations to bring to your attention. There are limitations on reasonable accommodations. If the primary one is if the accommodation requested would be a quote-unquote undue burden on the employer. That's the sort of term that ends up getting a lot of attention under the law. And by the way, these cases tend to be very fact-specific to lots of things, including what the employer's ability to provide the accommodation is. A larger employer will almost always have more significant obligations than a smaller employer because of the flexibility that their workforce provides. Decisions are made on a case-by-case basis, and the employer is not required to pick the reasonable accommodation that you, the employee, are requesting. If they have an alternative that would work for the employee can be forced to go in that direction. The State Human Relations Act covers all of these same things that the federal law covers, but notably, organizations with 5 or more employees are covered. So if you have a discrimination situation where it's a smaller employer not covered by the federal law, the state law will be the next place that you go to look for protection. The federal law is enforced by the Equal Employment Opportunity Commission, the state law by the Pennsylvania Human Relations Commission. And if you file a charge of discrimination with one of those organizations, you will have it dual filed, as they say, with the others. So you only need to file with one in order to protect your rights under both acts if they both are applicable. So that ends our introduction, including discrimination. Now we're going on to my favorite employment law, the Family Medical Leave Act. And this is why it's my favorite employment law. Unlike the discrimination cases where it is often quite difficult to know whether the law will apply or not, because it's more of an art than a science often, there are very bright line rules under the FMLA, and those rules can often be applied without a whole lot of struggle to save client jobs. In other words, what we often do at CLS is we have a factual situation that we can write a demand letter to an employer, explain why what the employer did violated the FMLA bright line rules, and the person gets their job back. People often think of the FMLA as covering quote-unquote leave as it is traditionally understood, which is something that's fairly long-term. And in fact, part of what you'll see as we go through this law is that very short absences from work can be covered under the FMLA, meaning that the client cannot be fired for that absenteeism. So whenever there is a situation involving absenteeism and medical reasons, you should think about whether the FMLA might apply. The demographics of FMLA use also confirm what I know from working with clients, which is that lower income workers are more likely to need the protection of the law because they are less likely to have flexibility built into their jobs and more likely to need it in order to justify having time off without being fired. Also because women are the caregivers in most situations, or at least many, majority of situations, the demographics of use show that they are more likely to take it than men. Men are more likely to use FMLA leave for their own personal medical conditions. So these are the types of time away from work that are protected by the FMLA. Of course, when you have a new child that comes into the family, whether by birth, adoption, or foster care. And then we get into numbers 2 and 3 on the bullets, that probably the most often used parts of the FMLA, where either the employee's own serious health condition makes him or her unable to perform the job, or the employee is needed to provide care relating to the serious health condition of the son, daughter, spouse, or parent. Note that that is a somewhat limited list of family members for which care can be provided under the FMLA. Sometimes they're defined more broadly. For instance, persons who are in loco parentis might be considered parents, but it does not include aunts, uncles, grandparents, what have you. In recent years, the law was amended to provide for care of people who are involved in military service, including not only just care for illnesses, but there could be exigencies that are related to being called to active duty. So for instance, if somebody is about to be called to duty and the spouse needs to be away to make arrangements in connection with that, that might be the sort of thing that's also covered. But we don't see the military issues presented too often in my experience. What the worker gets. Mostly the worker gets to keep his or her job, and that is not an insignificant benefit at all. This job preservation can be for up to 12 weeks in a 12-month period. If it's a military situation, up to half a year. And we'll talk more about this in a minute. In addition, health insurance continues during the leave under whatever other conditions the person had it while working. So if the person was making a payment towards the health insurance, that payment would need to be continued for it to continue. But if the health insurance was being provided free of charge, it will continue during the leave to be provided free of charge. And then, of course, when the person is ready to come back, they are supposed to come back to the same or equivalent job and get the same employee benefits that they had before. This law, as currently constituted, does not require you to be paid while you're on family medical leave. sometimes you can find alternative sources of income that might match up with the period that you are out of work, and we'll talk about that in a little bit. Okay, whether an employee is eligible under the FMLA is often the key to whether or not they're going to be covered. These are the most serious issues, and some of them are quite cut and dry. To be for an employer to be covered, usually the most important criteria is that they have at least 50 employees. And that means, of course, that smaller businesses tend not to be covered. Sometimes you might be able to lump together different facilities. Let's say you've got one employer that's got related restaurants. That can be a complicated thing to figure out. But usually this is pretty straightforward. Either the employer has 50 employees or it does not. The second thing is whether the employee is covered. And for the employee to be covered, all three of these requirements must be met. First of all, the person has to have those 50 workers working within 75 miles of their own work site. Secondly, they have to have been working for the employer at least 12 months. So that means newer employees will not be covered. And third, they have to be working at least 1,250 hours in the previous 12 months. So that means that they have to have some amount of work that, if they're part-time, it's got to be more than minimal or they're not going to qualify. On average, 25 hours over 50 weeks gets you to the 1,250 threshold. Another way that somebody might miss that number, aside from being more part-time than that, is if they've taken a lot of leave in a previous year, they may have a hard time meeting the 1,250-hour requirement. So really, for a lot of employees, the 12 months on the job and the 1,250 hours will be the crucial thing to know whether or not they have coverage. The third piece is, do they have a serious health condition? And if this session went for more than an hour, I would go through this with you at some detail. But since I don't know that, these are the regulations that you need to look at. And by the way, the FMLA regulations are extensive and extremely important to any advocate who is trying to figure out the law. This is one of the rare cases where reading the regulations is way more important than reading the statute if you go to apply the FMLA. But there are various different ways of describing serious health condition. It's usually tied to how certain health care is delivered. So, for instance, to give you an example of both that phenomenon and how minimal the treatment might be and still be a serious health condition, there's one example that a person is treated by a healthcare provider once in the healthcare provider's office, and then there's ongoing treatment, like potentially the provision of a prescription drug that is monitored by the healthcare professional. And that can be an incapacity that is fewer than 4 days. So to say that concretely, based on the regulations, if you had somebody who was out of work for 3 days, or even just incapacitated for 3 days, it might even be over a weekend when the person would not have been planning to work, has had this medical treatment of seeing a doctor once, been under supervised continued treatment like a medication, and they're now covered by the Family Medical Leave Act. So that is a fairly minimal health condition, potentially, and it is something that doesn't require a great amount of supervision by a provider, but that will be covered, and then the person cannot be fired for that absenteeism. And that's by way of making you understand how minimal an absence might be and yet have it be covered by the FMLA, which is why I want you to not think of this in the traditional thought of what is leave, because it can really be a couple of days absence. As I have said, another way of looking at what is leave, and this is really a key concept, is less that it's a lengthy time away from the job and more that it's protection from being fired for absenteeism. One thing that's really cool and is specifically addressed in the regulations is that an instance of absenteeism that is covered under the FMLA cannot be the basis to fire you under a no-fault discipline policy. So, for instance, many employers have a policy that might provide if you're absent one time, you get written up. If you're absent the second time, you get suspended. And if you're absent a third time, you get fired. Well, what this says is if you are fired at step 3, but looking back on steps 1 and 2, you can show that you were on FMLA leave, or what should have been covered as FMLA leave had the employer applied the law, then you can't be fired. So that's a very exciting limitation on an employer's ability to fire people for being absent. As I said before, the FMLA does not provide for income, does not provide for the employer to pay you while you're out. You have to think of job protection and income as coming from potentially different sources. And that means, for instance, that you might want to combine your FMLA leave with other paid leave. For instance, if you have an employer-provided disability policy, or if the employer provides sick, vacation, or personal time. Both the employee can choose to use that time, or the employer can force the employee to use that time to spend it down. So either side can decide you're going to be getting paid sick, vacation, or personal time while you're on FMLA leave. On the other hand, if you don't have FMLA protection, you really don't have job protection, even if you're on paid leave of some sort. You could be on short-term or long-term disability from your employer's insurance and be fired if you're not FMLA covered. You can be on workers' comp and be fired if you're not on FMLA leave. Conversely, those sources of income can provide money for you while you're out on FMLA leave, so you're not becoming totally destitute while you have to be out of work. All right, I'm going to take a quick swallow of water, and we'll talk about our last major subject, which is criminal records. As most people on this call probably recognize, criminal records are a huge issue, a huge employment issue, and an issue for our clients in other areas as well, such as housing, such as student loans, such as public benefits. In the employment arena, it is almost impossible at this point to get most formal jobs that are not in the underground economy if you have a record, because background checking has become prevalent in the last 15 years or so. According to the Society of Human Resource Management, 87% of employers of their members do background checks. That's actually down from 92% before the recession started. So I guess some employers decided to save money and not background check. But basically, people with records are finding now that they can't find work. Even if they found work in the past, I have a client who has told me that it's harder for him to get a job now than it was when he came out of jail in the 1970s because of the background checking. And for this reason, criminal records are by far the major cause of people coming into employment intake at CLS. And over the years, we've learned and developed a whole bunch of things that we can do for them. And that's what we're talking about today. The best thing we can do for a client is to clean up that criminal record. And inevitably, a majority of our clients who want their records dealt with come in asking for an expungement. I wish I could tell you that everything is subject to being expunged, but most often it's going to be arrests that have not led to convictions, and we'll discuss the criteria for that in a moment. Expungements are done by the courts, and they are a relatively quick procedure, especially compared to pardons, which in Pennsylvania is the primary way that a person with convictions can try to get them off their record. That's a very long, drawn-out process that begins with the Pennsylvania Board of Pardons and ends with the governor. If the Board of Pardons has recommended a pardon, the governor decides whether or not to accept that recommendation. We'll talk more about that in a second. The third thing we can do to help clean a record is to fix errors in the record. And as difficult as it might be to believe, there are errors all over criminal records, whether in the public sources of information or in the records that are prepared by commercial entities such as LexisNexis, HireRight. There are hundreds, if not thousands, of private companies preparing those records. We'll talk about all these things. This is currently what can be expunged in Pennsylvania. And let me start by saying most of these things cannot be considered by an employer under state law. I'll come back to that in a second. We'll go down the list first. What can be expunged? First of all, arrests that have not led to convictions. That could be any outcome short of conviction, whether the charges were dismissed, null prossed, acquitted, whatever you have. There might be different rules that apply depending on what the outcome was, but most arrests can be expunged. In many cases, juvenile delinquency adjudications can be expunged. And you might wonder, why does anybody want to expunge them? They're secret and private, aren't they? Well, the answer is juvenile court records are secret and private. But under state law, many juvenile delinquency adjudications go onto state police records. So I just got a very odd message. I hope that means you can still hear me. In any event, let me keep talking. So you'll want to get those juvenile delinquency adjudications off of the state police record if you have somebody who works in a field that state police records are used for screening, like in nursing homes or in daycare or schools. If your client went to a diversionary program where if they do what was asked of them in probation, pay their fines and costs, they're told it'll come off their record, those are other circumstances where an expungement can happen. In Pennsylvania, the two primary types of programs that are diversionary programs are something called ARD. Excuse me while I, oh, okay, all is well, I hear. ARD, it stands for Accelerated Rehabilitative Disposition. I don't know what that means, but essentially it's a program where you can do your probation and then get an expungement. Section 17 is for first-time drug offenders. Prosecutors have a discretion as to when they give this opportunity to people. Again, it's traditionally first-time offenders, not necessarily, but the person does need to complete the requirements of their ARD in order to get the case expunged. A relatively new type of thing, new type of expungement is the convictions of summary offenses. If you have been convicted of a summary like disorderly conduct, retail theft, now after 5 years, you can seek an expungement of that from your record. Then there's what I often call the Penn State expungement, underage drinking convictions. There's some period of time, I believe it's also 5 years, after which, if you've stayed out of trouble, you can get your underage drinking conviction expunged. And then another one that's not necessarily all that helpful for employment, but occasionally is, if you're 70 years old and have not been arrested in 10 years, you can get rid of your convictions. That is actually often most useful for people who are trying to get into senior housing. But we do occasionally see clients who are trying to work after age 70 and are running into criminal record problems. And finally, in Pennsylvania, if you are dead, you can get your record expunged. We don't do a lot of that one. In fact, I'm not sure we've ever done that one. There is some hope that this list is about to be expanded. There is a bill called Senate Bill 391 that has passed the state Senate and has a good chance of becoming law, we are told. It would, for the first time, make some misdemeanor convictions expungible. So hopefully in a couple of months I can do a webinar where I talk about Senate Bill 391 and how expungement has been increased. But as I started to say earlier, most of the things on this list may not be considered by employers under state law. That includes arrests, juvenile delinquency, diversionary programs, summary offenses. And the reason is that we have a state statute that you'll see the cite to later that says that only felonies and misdemeanor convictions may be considered by employers. So you may ask, what is the point of doing expungements if all of these things can't be considered under state law anyway? And the answer, of course, is that employers regularly violate that law. And so we have floods of people for whom we do expungements who are very, very happy to get them because even though they're not supposed to be turned down, that is in fact what is happening. Now, the process for getting an expungement is typically that a relatively pro forma petition is filed. It will often be scheduled for a hearing within, say, a month. It's all relatively quick by legal standards, and if the judge orders it expunged, which in Philadelphia at this point there's hardly even many contests at this point, the DA agrees, then the orders go off to the state police, the courts, the FBI, and it comes out of the public record. So it's a fairly good remedy that works fairly quickly. Involves a lot of paper pushing, but this is some of the most useful work that we do, because if we can clean up or eliminate people's records, their employment possibilities are greatly enhanced. Pardons. That, as I said before, is the method of trying to eliminate convictions for the most part. That is a totally different ballgame. That is a process through which you currently have to stand in line, figuratively speaking, for several years before your application is even considered by the Board of Pardons. So what a person has to do is to fill out a lengthy application that contains lots of essay questions, which our clients are often not very good at writing. So one of the things CLS does is to try to help our clients construct their pardon applications. Even though we are not allowed to write them for them, we can transcribe what they have to say and make some suggestions about what they might want to address. So that application is filled out, and it gets filed with the Board of Pardons, and you wait for several years because of the lengthy line of applications ahead of you. You might think, well, what is the point? And the point is that people actually get pardons. Pennsylvania is one of 14 states in which a reasonable number of pardons are granted. I think there are usually about 300 a year, almost always for employment-related reasons. And so for clients like ours who manage to get them, it can be a life-transforming type of thing. And it is certainly worthwhile. I've often had clients come to me and say, oh, I don't feel like doing this, it's so long, and then they return 5 years later and say, darn it, I should have done it 5 years ago. If people are in a position where they might get one, encourage them to try it. There's nothing much to be lost except the time that's put into preparing the application. Generally, people should wait at least a decade before applying for a pardon of a felony, 5 years for a misdemeanor. Even longer is better, but they need to be able to take responsibility for what they were convicted of doing and explain why they need a pardon. And part of the scary thing is that they need to go to Harrisburg and stand up in front of the Board of Pardons in a very ornate courtroom and explain themselves if they're lucky enough to get a hearing. So there is some, commitment to this process that's required, but I have a couple clients for you who could tell you how worthwhile it has been for them to go through this process, even though it is scary. The Board of Pardons is constituted by state constitution. It includes the Attorney General, the Lieutenant Governor, a victim's rights person, who is typically the most employee-friendly person on the board, a correction officer, expert, and a psychologist. And they, you need 2 votes to get a public hearing. In Harrisburg, when you show up for the hearing, you need 3 people to vote for you. If they do, then you move on to the governor, where hopefully you get your application granted. And then you do an expungement to get everything off your record. Again, I do highly recommend trying this, but consult with CLS if you need more information, because there is definitely art to this. And we've seen many people get turned down simply because they don't quite play their cards right, rather than that they wouldn't necessarily qualify. All right, so we talked about expungements, we talked about pardons. Those are the ways of getting rid of your record. Now we're going to talk about limiting employer consideration of criminal records. And the most important statute here is Title VII, which we talked about earlier. That's the race discrimination law, federal law that prevents race discrimination. And in addition to intentional discrimination, Title VII prohibits policies that are not intentionally discriminatory but have a racially disparate impact. And essentially, that is how criminal records become covered by Title VII. Because African Americans and Hispanics are more likely to have involvement with the criminal justice system, an employer's policy about criminal background checking will tend to have a racially disparate impact. As a result of that, the employer has to show that they have a business necessity for having that background checking policy. And that's not just the fact of having a policy, but the contours of the policy. So if you were to pursue a claim of discrimination, or even argue with an employer about it, to start with, you don't need to show racially disparate impact. It is presumed that an African American or a Hispanic has been victimized by disparate impact. You argue that the policy is not justified by business necessity because it is overbroad. And I commend you to a really important development from last year, a new enforcement guidance from EEOC on the issue of criminal records. When I first looked into this subject, I was astonished to find that the most important policy was from 1987 and had Clarence Thomas's name on it, the current Supreme Court Justice. He was the chair of EEOC at the time, and there's been a lot of support we've gotten from the fact that Clarence Thomas has recognized for decades already that this is a form of race discrimination. It is not some overreach by EEOC to say that criminal records are covered by Title VII. But the new guidance is really terrific. It's so terrific that just last week the state of Texas filed a lawsuit against the EEOC to try to declare it illegal. But unless and until you hear that that has happened, which is highly unlikely, that guidance is the document that you want to look at. So here are some important lessons to take from that guidance. First of all, under Title VII, and as construed by EEOC, an arrest by and of itself generally will not justify an employer turning you down for a job. So both the state law, which we talked about earlier, and Title VII provide a basis for saying, employer, you can't turn a person down based on an arrest. Now, it is possible if an employer actually evaluates the conduct that the person allegedly engaged in, that they can say that that's an independent and legal source for turning that person down. So let's say the person was already working for the employer and got suspended because the auditor found that they were stealing from the employer. Well, certainly, basing it on that set of facts rather than the fact of an arrest is going to justify letting that person go. But an employer who just gets a rap sheet that says this person was arrested for aggravated assault in 1994 and the charges were dropped, that will not, in and of itself, justify an employer in turning that person down. It will be a form of race discrimination if the person is black or Hispanic. Now, if the person has been convicted, these are the major factors that the courts and the guidance say should apply to an employer's reasoning. The employer is supposed to look at the nature and gravity of the offense. So obviously the more significant and severe it is, you know, murder and rape are much more important than littering on the public highway. Makes sense. The EEOC says, secondly, that the employer should consider the time that has passed since the offense. That also makes sense and has been basically verified by social science in the last few years. Social science tends to show that the longer time has passed since you commit your offense without reoffending, the less likely you are to do it again. And the third thing is, what is the nature of the job compared to the criminal record? And that makes sense too. If you are a convicted embezzler, you should not work as an accountant. However, if you have a DUI and your job does not involve driving, does it really make a difference? Probably not. So these are the three factors that are the bedrock of considering convictions. And as you can see from the site, they go all the way back to 1975. The second important federal law that applies to convictions, oddly enough, it may seem, is the Fair Credit Reporting Act. And this is a consumer law. And you may wonder, why is it coming up in an employment law session? Well, it's because it applies to commercial vendors like LexisNexis that prepare criminal background reports. And when it comes into play, because an employer has hired a background preparer, your LexisNexis, it creates obligations on both the company that prepares the report and the employer that purchases it. It does not apply to public sources of criminal records, so it does not apply to the state police, to the courts. Here are the most important rules that apply to the preparers, like your LexisNexis. First of all, as a general rule, they cannot report arrests, now not convictions, they can always report convictions, but arrests that have not led to convictions, if they're more than 7 years old, they should not be on the report. Secondly, they're supposed to use, quote-unquote, reasonable procedures to, quote-unquote, ensure maximum possible accuracy. This is not a strict liability standard. In other words, just because the record is wrong doesn't mean that they're liable. But they were supposed to really do the best they could to make it right, is a shorthand way of describing that test. And finally, when one of these things, these records is bought for employment purposes, which is our topic today, as opposed to, say, landlord-tenant purposes, then the employee either should get concurrent notice of the report, or the employer has to have strict procedures to be complete and up to date. Now, do they do these things? No, not necessarily. In fact, CLS has numerous class actions, either pending or that we previously litigated against background preparers. And these are some of the most common things that they do wrong. They get things wrong. For instance, they might say something that is a misdemeanor is a felony. A really upsetting one is that they mismatch the person that they're doing the background check on against other people's records who have the same name. So to give you a for instance, we're preparing a case for a client named Jose Flores, who, of course, has people throughout the country with the same name. And the background preparer basically attributed every case in the country that was brought against a Jose Flores to our client, resulting in 64 pages of cases that did not belong to him. Needless to say, that does not help you get a job. That is an extreme example, but not an unusual one. Sometimes they include cases that have been expunged. They don't take them out of their own databases. Sometimes they report the same case over and over and over again, making it look like the person has many more cases than they actually have had. As I said, even the employers have some rules that apply to them if they purchase these records. One is that they have to get clear written notice that the report might be sought and written authorization from the person. That is not true of a background check from a public source, like the court's website, for instance. But most employers do buy their background checks, so this will apply in most cases. If the employer intends to turn that person down or fire them, the applicant is supposed to get a copy before that action is taken. That is both so that the employee can dispute the report if it's wrong, and so that the employee can say, yes, it's correct, but think about the following before you turn me down. It gives them a chance to put their best foot forward. And then if they are in fact turned down for an adverse report, they're supposed to be told that so that they can take action. Finally, and it's good because we're running out of time, let me just say this about wages. People often think of the Fair Labor Standards Act, the federal statute, as the wage law. It's a very important one, but it goes all the way back to 1938 as the New Deal and has limited coverage. It really only applies to calculations of minimum wage and overtime. In many ways, in Pennsylvania, the more important law is our state wage payment and collection law, because that allows you to get all the wages that were not paid to you. So if you're paid anything above minimum wage and the employer stiffs you, such as doesn't pay you at all or withholds for losses that the employer has sustained, or you've been let go or you've quit and the employer has refused to pay you the last paycheck, those are all common wage cases that we see. You want to get the rate above minimum wage, you file under the Pennsylvania wage payment and collection law. And I think that ends my presentation and my time. And I thank you for your attention, and I do in fact welcome questions by email. If you don't have my email address, here it is, write it down, Dietrich, D-I-E-T-R-I-C-H, @CLS, like Community Legal Services, PHILA, P-H-I-L-A, like Philadelphia.org. So that's Dietrich @CLSPhila.org. And that's what I got for you today. There you go. It's a quick coverage of employment law in 1 hour. I hope you found it useful, and I thank you for attending the webinar. Take care, and bye-bye.